Hello, everyone, and welcome to Uncivil Law. And for today's case, we have a story you may have heard in the news. The Texas government had some boxes that you could drop off ballots in, and the Texas government limited it to one box per county. So this got a lot of news attention, and there's a court case behind it. And so we're going to read this court case and try to figure out exactly what is going on in the situation and whether or not the governor ordering one drop-off location per county is legal or whether it was an abridgment of people's voting rights. Let's get started with this. Texas law allows eligible voters to vote early, either by mailing in ballots or by personally appearing at an early voting place. Governor Abbott issued a proclamation expanding early voting options for the upcoming November 3rd election beyond those provided for in the Texas Election Code. Among other things, this proclamation authorized early in-person voting to begin on the 13th instead of the 19th, thus allowing 6 additional days to vote in person. The proclamation also expanded opportunities for delivering mailed marked-in ballots to an early clerk to a voter office. Previously, voters wishing to hand-deliver their ballots could only do so while the polls were open. So you could get an absentee ballot and you could either mail it in or you could deliver it by hand, but you could only deliver it by hand under the law before on election day. And that the governor changed that to allow you to hand it in person other times as well. So the proclamation suspended the requirement to allow the voter to deliver a marked ballot to the early voting clerk's office prior to and including the election day. This had the effect of extending the amount of time for a voter to hand deliver this mailed-in ballot. As the Texas Director of Elections explained in the case, because counties began sending mail-in ballots on or before September the 19th, the proclamation included opportunities for voters to hand deliver these marked-in ballots from only one day, where they could deliver by hand, namely Election Day, to over 40 days. Additionally, of course, voters retain the ability to send their absentee ballots in by mail, so you can actually mail them as well. Following the proclamation, at least 4 Texas counties, Harris, Travis, Fort Bend, and Galveston, announced their intention to have multiple mail delivery locations located in their county for the November election. The governor then issued a second proclamation, in which he clarified the prior suspension of the law concerning hand delivery of mail-in ballots applied only under certain conditions. First, a voter must deliver the ballot at a single early voter clerk's office location that is publicly designated by the early voting clerk for the return of the ballots under the operative law and the suspension. Second, the early voting clerk must allow poll workers the opportunity to observe any ballot delivery. Finally, the proclamation specified that any marked mail ballot delivered in person to the clerk's office prior to October 2nd shall remain subject to the July 27th proclamation. So anyone who did hand in their ballots at any of these other locations are still covered, but as of this date, you can't do it except through the single designated location. So is that proper? As to the merits, the district court evaluated the plaintiff's voting claims under a balancing framework. It found that the proclamation issued by the governor burdened voting rights somewhere between a slight amount and a severe amount, and I'd just like to take note that covers a lot of ground, because it forced absentee voters to choose between risking exposure to the coronavirus to deliver their ballots in person or to be disenfranchised if the Postal Service was unable to deliver their ballots on time. The district court found this burden outweighed the state's professed interest in ballot security, election integrity, and voter safety. So the district court said that the people have to choose between risking exposure by delivering it in person, or they have to take the chance that the Postal Service may not be able to deliver it in time, and therefore we should have multiple drop-off locations to solve this problem. So was that correct? In deciding whether to grant a stay pending this appeal, whether or not we should enjoin it, we evaluate whether the stay applicants have made a strong showing that they're likely to succeed, whether the applicant will be irreparably harmed, whether the issuance of the stay will injure other parties, and whether the public interest lies, and this standard should be fairly familiar to you. We covered quite a lot. As to the plaintiff's voting rights claim, the district court applied the Anderson-Burdick balancing test. A severe burden on voting can be justified only by state rules that are narrowly drawn to advance a state interest of compelling importance, which sounds suspiciously like strict scrutiny. Lesser burdens, however, trigger a less exacting review, and a state's important regulatory interests will usually be enough to justify reasonable non-discriminatory measures, which sounds suspiciously like intermediate scrutiny when we're talking about an important interest. The district court classified the burden on plaintiffs' right to vote as somewhere between slight and severe, which again covers quite a lot of ground, because due to the order, absentee voters must choose between risking exposure to coronavirus to deliver their ballots in person or to be disenfranchised if the Postal Service is unable to deliver the ballots on time. This burden, the court reasoned, outweighed the state's active interest in security and other things. As to that, we, the appellate court, say the district court vastly overstated the character and magnitude of the burden allegedly placed on the voting rights by the proclamation. Indeed, one strains to see how the proclamation actually burdens voting at all. After all, the proclamation is part of the governor's expansion of opportunities to cap absentee ballots in Texas well beyond the stricter confines of the election code. Previously, as we've explained, mail-in ballots could only be hand-delivered to the election clerk on election day. The governor's proclamation effectively extended that hand delivery option by 40 days, and the impact of the October 1 proclamation can be measured only against this operative baseline. To be sure, the proclamation requires a single designated drop-off location per county during the period, but that represents merely a partial refinement of the bounds of still existing expansion of absentee voting opportunities. We're still giving you more, however limited the more may be. In a related context, we have explained that to abridge the right to vote means to place a barrier or prerequisite to voting or otherwise making it difficult to vote. By contrast, a law that makes it easier for others to vote does not abridge any person's right to vote. The July 27th and October 1st proclamations, which must be read together to make sense, are beyond any doubt measures that make it easier for Texans to vote in absentee. How this expansion of voting opportunities burdens anyone's right to vote is a mystery. So the court here is pointing out that the popular press on this may have been somewhat less than accurate. So some of the press that you've been receiving from the national media has said Texas is really, really horrible for taking away all these voting locations, these personal drop-in locations, restricting them one per county. And the court is a little bit like, what are you talking about? These things didn't exist at all prior to like this 27th of September. There were no drop-off locations at all. They didn't exist because you had to drop them off in person on election day. So, yeah, there's only one of them, but they're there for 40 days. And you say that's bad because they're taking them away, but they didn't exist before. So they're not taking them away. They're giving them when they didn't exist. How is this restricting your right by giving you more options than you had before? The court is confused. It's possible the national media may have somewhat been lying to you about this story. The district court emphasized that some absentee voters would have to travel farther to drop off mail-in ballots at a centralized location, and that, as a result, they would confront a higher risk of exposure. The court also warned that voters unwilling or unable to do so would risk disenfranchisement if the USPS is unable to deliver the ballots on time. This drastic picture painted by the district court fails to account for the numerous ways Texans can vote early or absentee in the November 3rd election. As we've recounted under the governor's expansive voting opportunities, Texans can vote early in person for an extended person starting on the 13th, as opposed to what was before on the 19th. They can hand deliver a mailed ballot during a 40-day period, as opposed to the previous one-day period, or they can drop off the absentee ballot into the mail. In light of these options, the proclamation's partial refinement for one avenue for absentee voting does not amount to a severe restriction on the right to vote because, we gave you more options to vote than we did before. The district court undervalued the state's interest further in the proclamation. Even assuming the proclamation poses a burden on rights, which is difficult since we gave you more than you had, the burden is minimal and would trigger less exacting review, meaning that a state's important regulatory interests will usually be enough to justify a reasonable, non-discriminatory restriction. States have critically important interests in the orderly administration of elections and vigilantly reducing opportunities for voting fraud. Wait a second, voting fraud? I've been reliably told by the media that any idea of voting fraud is a myth. There's no voting fraud here. Who thinks there's voting fraud? Indeed, both the Supreme Court and our court have recognized that mail-in voting is far more vulnerable to fraud than other forms of voting. Oh, that would be who? That would be who's recognized mail-in voting as potentially problematic. That'd be who's recognized mail-in voting as susceptible to more fraud. The U.S. Supreme Court has said that. The U.S. Supreme Court has said that mail-in voting is susceptible to more fraud than other kinds of voting. Oh, maybe it wasn't just a talking point. Maybe there's evidence to this. But when did the Supreme Court say those things? I'm so glad you asked. For example, in our case law, in Velsey versus Abbott, we said, En banc, incidentally, that would be the entire court of the Fifth Circuit sitting, en banc, observing that, in contrast to in-person voting, record evidence shows that mail-in voting is far more vulnerable to fraud, particularly among the elderly. Also saying en banc, we criticize the challenge law because it does nothing to address the far more prevalent issue of fraudulent absentee ballots. Interesting. Also see, for example, a case from the United States Supreme Court, in which the United States Supreme Court discussed examples in recent years of fraudulent voting perpetuated using absentee ballots and not in-person fraud, demonstrating that not only is there a risk of voter fraud is real, but it could have an impact on the election. Citing a decision from the Court of Appeals, observing that courts have repeatedly found that mail-in ballots are particularly susceptible to fraud. So yeah, I mean, all those media sources that told me, all those media sources that reliably told me that mail-in voting fraud, who's talking about that? Well, the Court of Appeals, en banc, the U.S. Supreme Court, a different Court of Appeals, they all have said, mail-in voting looks like it might be susceptible to additional fraud, particularly concerning the elderly. Maybe it's not just a talking point. Maybe actual courts have actually found this. Okay, well, maybe once again the media has lied to you somewhat. It is therefore evident that Texas has an important regulatory interest in deciding how its citizens' votes are counted and collected. This interest is acute when it comes to mail-in voting. See also, for example, Vesey concluding that mail-in ballot fraud is a significant threat. Mail-in ballot fraud is a significant threat, says, a court. As explained, the proclamation is part and parcel of a sizable expansion of absentee voting options occasioned by the governor's pandemic-related orders. Opportunities for the absentee voters to hand-deliver their ballots ballooned from the pre-COVID 1 day to the in-COVID 40 days. The evidence showed that this expansion of absentee voting provoked an increase in drop-off locations in certain counties. While the reaction is understandable, it is also understandable the governor's goal of centralizing delivery locations and deploying poll watchers there in order to maximize ballot security, because there will be people there actually to watch. Unlike, we can't put people everywhere, so we can ensure the ballots are being dropped off by, authorized people and such. Maybe that's a good idea. We turn to the plaintiff's equal protection claim. Because the right to vote is fundamental, once the franchise is granted to the electorate, lines may not be drawn which are inconsistent with the Equal Protection Clause of the 14th Amendment. The district court held the plaintiffs were likely to show the October 1st proclamation violated these principles by imposing disproportionate burdens on voters based on where they live. Plaintiff argued the elimination of additional drop-off locations would force voters into large and populous counties to travel farther, wait longer, and risk increased exposure to the coronavirus. Meanwhile, voters in smaller and less populated counties would not face the same difficulties. The Secretary for State for Texas is likely to show that this analysis is mistaken. As with the voting rights claim, the district court misconstrued the nature of the alleged burden imposed by the order. It is true that equal protection guarantees to every voter that every equal voter is equal to every other voter in the state, regardless of race, sex, occupation, wealth, or residence. But the district court accepted the plaintiff's contention the proclamation doles out electoral opportunities based on county lines. This is incorrect. The plaintiff establishes a uniform rule for the entire state. Each county may designate one early voting clerk's office at which voters may drop off ballots during the 40 days leading up to the election. The voters who live further away from a drop-off location may find it a little inconvenient to take advantage of this particular additional method to cast the ballots, but that does not limit opportunity, as the district court thought, because, you couldn't have done this before. One is more than the zero you had before. The fact that the expansion is not as broad as plaintiffs would like does not mean that it has limited their rights, because it has actually expanded them. It is the opposite of limiting. It has expanded. One is a bigger number than zero. Why are these complicated concepts? I do not know. Having concluded the Secretary of State for Texas will likely succeed, we address the remaining factors: whether the Secretary's irreparable harm, and whether the issuance of the stay will substantially injure other parties, and whether the public interest is gained by the injunction. The Secretary has shown irreparable harm. When a district court injunction prevents the state from effectuating its own election procedures put in place by election officials, it suffers irreparable harm. Issuing a stay will not substantially injure the plaintiffs, who retain numerous avenues for casting their absentee ballot under expanded voting opportunities afforded by the governor's proclamations. We finally conclude the public interest favors the Secretary. When a state is a party appearing in an injunction, its interest and harm merge with that of the public. Because the Secretary has met the burden, we exercise our discretion to stay the injunction pending the appeal. Thus, that brings us to the end of the case of Texas League of United Latin American Citizens versus Ruth Herges in her official capacity as the Texas Secretary of State. In this case, we learned that a bunch of people sued the Secretary of State because the Secretary of State took away remote voting locations. And the Fifth Circuit Court of Appeals is like, what are you talking about? Under normal election rules, there are no remote locations. You can only drop them off in person on election day, which incidentally you can still do. But you also, if you want, can drop them off in this box. And this literally was not an option before. So the fact that there is one box instead of 0 boxes has somehow limited your rights. And you say that this is, and also you could, mail them in. That's still an option too. If you want to mail, that's possible, and that was also an option before. And also, there's a huge early voting period, and you can go to any voting location in your district. There are many of them. You can go to any of them, and you can vote early in person if you like. There's a whole bunch of options, and the Texas governor only gave you more options. So your complaint again was what? So yeah, once again, maybe the media didn't give us the best perception of this case when they described it the way they did in the popular press. But at least for the moment, that brings us to the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. If you liked this latest video, please give it a like below and hit the join button. For 99 cents a month, you too can give a recurring membership that helps this channel grow and helps YouTube to recommend this channel to others. We really appreciate your continued financial support and all your love. And until later, my friends, cheers and goodbye.